This program is brought to you by Emory University.
I want to welcome everybody on behalf of Emory Law, the American Immigration Lawyers Association, and the American Civil Liberties Union of Georgia. So I think we're going to go ahead and get started, okay? When most of us think about prisons, we think of a facility owned and operated by the government, either the Federal Bureau of Prisons or perhaps the State Department of Corrections, and that prison would house criminals serving prison sentences after a conviction or people who are temporarily held for a cool-down period, perhaps to sober up after a DUI or to calm down after a physical or domestic altercation. But increasingly, more and more prisons are actually run by private companies. You can buy stocks in two of the largest prison companies, just like you can buy stocks in Walmart or McDonald's. Because these are for-profit ventures, their driving aim is to produce a profit. And lately, they've been doing an excellent job of that. In 2011, Corrections Corporation of America, or CCA, made $1.7 billion. And the GEO Group, which is CCA's biggest competitor, made $1.6 billion. From 2002 to 2009 alone, the private prison industry grew by 37%. The fastest growing market for these prisons is not convicted criminals. It's actually immigrants. Most immigrant detainees have not been convicted of or even charged with any crime at all. In fact, the number of detainees without any criminal convictions has doubled from 2005 to 2009. U.S. immigration policy allows for all types of non-citizens to be detained, including legal permanent residents, asylum seekers, single mothers, the sick, elderly, and even children. So who are these prison companies and what is their business model? To answer some of those questions, we're going to watch a short 2-minute clip from Cuéntame. So.
The detention of migrants is a multi-billion-dollar industry.
One in which immigrants are traded like products.
They are for sale to the highest bidder.
Who benefits and who profits? Corrections Corporation of America, or CCA, the GEO Group, and the Management and Training Corporation combined own over 200 facilities in the nation.
With over 150,000 bed spaces for a total profit of close to $5 billion per year.
Private prisons profit like a hotel. The more occupants that go in, the more money comes out.
You just sell it like you're selling cars, or real estate, or hamburgers.
Private prisons rely on anti-immigrant laws that guarantee them access to fresh inmates.
Here's how they do it. The American Legislative Exchange Council, or ALEC, is an extreme right-wing membership organization comprised of state legislators and powerful multinational corporations, including the Corrections Corporation of America.
ALEC is the most active private prison lobbyist group, pushing for anti-immigrant laws like Arizona's SB 1070.
Russell Pierce, like CCA, is an ALEC member, one with obscure ties to national white separatist neo-Nazi groups. During an ALEC meeting, CCA and Pierce crafted a model legislation that became, almost word for word, Arizona's SB 1070.
Whether people are undocumented or not doesn't matter.
As long as they fill the detention facilities for days, months, or even years.
SB 1070 and their copycat laws sprouting up across the country represent the perfect money machine.
Okay. So I'm going to Sorry. I just don't want it to be, okay. So I've got a really great lineup of panelists here. I'm going to briefly introduce all of them. Right here to my immediate right is Dulce Guerrero. She's an activist for undocumented persons. She is a member of DREAM Act Georgia and the National Immigrant Youth Alliance. To her right is Mr. Hernandez. He's an undocumented person in immigration court right now proceedings, seeking relief so that he can stay here with his wife and 2 children who are U.S. citizens. He was detained in Stewart and in Irwin, and those are 2 detention facilities here in Georgia. While he was there, private guards mistreated him and he lacked access to medical care. To his right is Professor Price. She's a professor here at Emory Law. Among other classes, she teaches citizenship and immigration law. To her right is Amna Shirazi. She is a successful immigration attorney here in Atlanta. Her practice focuses mostly on deportation defense, detention, and asylum, among other immigration issues. And then to her right is Azadeh Shahshahani. A lot of you probably know her from a lot of things around here. She's the director of the National Security and Immigrants' Rights Project here at the ACLU of Georgia. And she's also the editor of the report upon which this entire panel is based, called Prisoners of Profit. So I'm going to start with the questions. First, Professor Price. Let's get out of the way a question that we hear a lot, all the time. Aren't illegal aliens breaking the law, and isn't the law of the land that they should not be here and they ought to be deported?
Well, before I answer that question, let me stall a little bit by thanking you for moderating the program, but also thanking the people who are here who've taken their time from busy schedule to help our educational effort and our educational goals here at Emory Law School, and thank you all for being here. So the question of illegal aliens, no, it is not a criminal offense to overstay a visa and so forth. In general, no, it is a civil affair. Immigration courts that are involved in removal are not constitutional Article III courts, and as we'll talk about later on, the same kinds of constitutional rights do not apply to persons who are non-citizens when they are involved in removal proceedings, as would apply if it was a criminal proceeding against a United States citizen. So if I could just briefly explain why that is, and then we can get into it in more detail, or perhaps if you have questions from the audience and we hear more from the real specialists here. It's called plenary power over immigration, and Congress has plenary power over immigration, but in no other area of United States law is Congress's legislative power more complete and the limits of judicial review more restrained than in immigration law. It's for historical reasons. It's partly a result of an international regime that has said historically that nation states have control over who is admitted and who to make citizens, with certain restrictions, of course, with treaties for refugees and so forth. But it's been long-standing proposition in the United States. So basically the plenary power doctrine is based on 3 propositions. And the first of those is that a nation has the sovereign right to regulate immigration. So courts can't review Congress's decisions about who is admitted, who is expelled, under what terms you stay here. Congress could make it a crime to overstay a visa. They haven't. But it's plenary power. The issue is whether the judiciary can apply constitutional constraints to what Congress does with immigration. So that's the first one. A nation has sovereign right to regulate immigration. The second is the proposition, has been longstanding in the United States, that non-citizens have a revocable license to be here that Congress can take away. And if you look at our history, you'll see, beginning with the Chinese Exclusion Acts, that from time to time Congress has, in fact, taken that away. And it's, again, part of their plenary power is the judiciary says more or less, well, that's a political question. We're not going to review that. Congress is the final word on who comes in and who stays and under what terms. And then finally, the third point is, probably follows from everything that I just said, is immigration is a political issue. And the key difference that we'll talk about is in terms of constitutional rights of citizens versus non-citizens. It all sort of goes back to this plenary power doctrine.
Thank you. The next question is for Ms. Guerrero. Can you please tell us a little bit about how people end up in detention in the first place?
Good evening to everyone. My name is Dulce Guerrero. I am 19 years old and I am undocumented. So to answer the question, how do people end up in detention centers? So I live in Cobb County. Cobb County is a county called a 287G county. The 287G is a program that was started in Cobb County in 2007. 2008, and basically it's an agreement between local law enforcement and immigration. And it basically states that if someone is arrested in Cobb County for driving without a license, if they're stopped at a checkpoint, if, for example, they have a broken tail light sometimes, or their tags are expired in their car, they're pulled over by the police officer. The police officer asks them for their license. When they're not able to provide a license, they are taken to Cobb County Jail. When they're taken to Cobb County Jail, they get something called an ICE hold placed over them. So when this ICE hold is placed over them, immigration has 48 hours to pick them up. Within that time frame, immigration interviews them, asks them questions about when they got here, how they got here, if they have family here, whatnot. From there, they pick them up and they take them to a detention center. And like mentioned before, there's a couple detention centers in Georgia, Irwin Detention Center, Stewart Detention Center. So they're taken to these detention facilities where they're kept in here for days, like the video said, sometimes months and sometimes even years, for simply driving without a license. So simple things like a broken tail light, checkpoints. They always put checkpoints specifically where I live in Cobb in front of the Hispanic neighborhoods. So at the trailer parks, like right in front, they'll put a checkpoint. And we have pictures of it. We already know. So as soon as a checkpoint hits, I start texting people, and those people start passing the text on, and now everybody knows there's a checkpoint in front of the trailer park at whatever time it might be. So checkpoints are very common in Cobb County. Broken tail lights, that's also another excuse they always use to pull folks over if their tags are expired. But simple reasons like that, or whatever the reason may be. We had a case of a student who he was actually victim of a drunk driver, meaning that he was driving and a drunk driver hit him. So when the cops showed up, they realized that he didn't have a license, so they arrested him and they took him to Cobb County Jail, which then triggered his deportation. He's currently in Mexico now. Despite being a student, despite having all the grades, despite never being in trouble with the law at all. You know, he ran into an accident that wasn't his fault, and he ended up deported because of it. So simple things can trigger a deportation like that.
Thank you. Ms. Shahshahani, this next question has two parts. We saw in the video that companies make money per prisoner per day. How do they get the money from the government? And the second part is, how is that money used to lobby for laws like HB 56 and SB 1070?
Right, so I also wanted to thank the students for organizing this event, especially the Latin American Law Association and Laura Rivera and yourself for really putting all the effort behind this panel. So definitely the corporations play a very big part in the immigration detention system, and it's really turned into an industry. I mean, as the movie may have mentioned, there's now 49% of immigrants are held in facilities operated by corporations, including 3 out of the 4 facilities in Georgia now are operated by corporations, 2 of them by the Corrections Corporation of America, which is the largest prison corporation in the country, and 1, the Irvin County Detention Center by the Detention Management Corporation. And obviously, there's a lot of money in this industry. So just to give you an idea, CCA, the Corrections Corporation of America, earned almost $1.7 billion in 2010. And so basically, you know, they enter into contracts with local counties and with ICE for operation of these detention centers. And their selling point is that we're going to save money for you, for the government. And in fact, the way that they do that is by cutting down on the expenses for immigrants, you know, the living, for the living conditions and the food. So, for example, the people that we spoke to at the facilities are all given really poor food, really small amounts of food. They have all lost weight. And another way that the companies save money, so for example, the Corrections Corporation of America has a so-called voluntary work program, which in fact is not voluntary. We spoke to detainees who said they didn't want to continue working, but they were forced to. But basically, the detainees are paid $1 to $3 a day for cleaning the bathrooms and the kitchens in unsafe working conditions, performing the work that a company like CCA would have had to pay people to perform, minimum wage. And so that's just one of the ways. And it's really hypocritical because, CCA comes to these very poor counties, so Stewart County, where the Stewart Detention Center is based in, the largest detention center in the country, also happens to be the poorest county in Georgia. And CCA comes to this county and says, we're going to bring all this money and all of these jobs, and then they end up getting the detainees to do this work. And so in terms of your second part of the question, in terms of the lobbying, it's been documented there was an NPR investigation that showed that CCA had a very important role in crafting SB 1070, the Arizona law, and pushing it through the Arizona legislature, because obviously it's very directly related to their profit making. More immigrants picked off the streets means that more beds are going to be filled in the detention centers. And so CCA and other corporations have spent a lot of money in the past few years lobbying both the federal government and the state legislatures. So for example, in 2010, CCA spent almost $1 million lobbying the federal government.
Wow. So, Mr. Hernandez, building off of the first part of Ms. Shahshahani's answer about the conditions in the detention facilities, do you mind telling us a little bit about Stewart and Irwin while you were there, about the conditions there?
Hello, good evening. Well, you all know my name is Jose, and I was a detainee on Irwin County and CCA Stewart Detention Center, and I was for 3 weeks on Irwin, and when I first got there, it was like I was sick, and I tell everybody that I was sick, and nobody care about it. And they throw you in the cell. They don't. You ask for they ask you for you to fill out a form. That way you can go to the doctor or whatever, and they never give you. They never give you that page that you need to fill it up. That way you can get a medical attention. So I was there. I have chronic sinuses. When your sinuses get really bad, you got to take antibiotics. If you don't take it, you can get a infection on your head that you can even die from it. So I had that when I was there for about a week. And I couldn't get a medical attention until I called my lawyer. And I told my wife to tell my lawyer that I wasn't getting no medical attention. And when my lawyer called them, immediately, somebody hand me a page like that one over there, and they take me to the doctor. And they just check me up. They don't give me no pills. And they put me back on, and then I call my lawyer again, and I tell my wife that you do something. She was outside. I couldn't do anything in there. And and they end up giving me some Tylenol, I think it was, and that's it. And then another thing that they don't classify people in there. I'm not a criminal, but in the cells that I was, there were like maybe 40 persons, but they all come from jail to serving time for they've been serving from 2 years and up. And I don't have a criminal record. I don't even have a ticket. I never been pulled over. I never have get in trouble. My record is clean anyway. Any way that you can look at it is clean. I don't have nothing. And they throw me there with all those people, And I was concerned about my safety there, but since I'm I've been raised like you gotta stand up whatever you are, you gotta, make friends and stuff. I got through that, and after 2 weeks, I never got actually medical attention. A doctor saw me once, and he say, that he don't have my records before they move me to a store, because they have you there for like some time. When their money wear out of me, they send you to another prison, like a Stewart. So they have me in there for like almost 4 weeks, and that's what the government was paying them. When before they moved me, I saw a doctor, because, and he was asking for my records that I was sick there, and he couldn't find them. And out of that, they treat you like worse than a criminal, you know. They put you like shackles everywhere. You go like this, you walk like this through the bus and everything. You know, if you get out of the cell, you walk like this. If they're gonna move you anywhere, they're gonna take you to court. Anywhere they take you, they shackle you like you're gonna kill somebody. And on the Stewart Detention Center, I was there for almost 3 months. It was a little better. The food was better. But out of all that, and I had an altercation with the people that they have in there, to like the guards and staff in there. They're not like, I don't think they even have a high school, you know. And they treat you like you're a dog, like you're nothing. They try to. There is no like how you say that. There is no words to describe the way they treat you, because after you have all these problems outside, that you have your family. I have 2 kids and my wife outside, and I was the support for my family. And I got there, and these people treated me like I was a dog, you know. You can treat better a dog than me, you know. And it was kind of hard for me and my family. And one of those days that I was on a store, I had a really bad altercation with the security guard. And he told me that he had the power to put me in jail, to keep me there for 100 days without nobody knowing me. Nobody know that I was there for 100 days. And he can tell immigration, because I just speak up myself. You know, I tell them that I treat them with respect, and I want them to treat me the same way. But he get all upset, and he just went out on me, and he tell me really bad things. You know, he treat me like, I never tell him any bad words or anything. My English is not that good, but I understand what the people say, and I speak a little bit. So I did understand everything that he said, and everything started because one of the guys, they have these cells, they're like this room like over here. They have 31 beds on this side over here, bathrooms over there, and little 4 tables over here, and there's 60 people in there. They have bunk beds. And one of the guys, he was bleeding from his ear, but you know, it was a lot of blood coming out of his ear. So we called the security guard, and they come and they say that they don't give a if he died or what, but he got to fill up the piece of paper. That way he can go the next day to get a medical attention. So I speak up myself, and I tell everybody, hey, that we cannot, you know, they cannot doing this to us, and we got to take this guy to a doctor. And everybody start telling to the guards, take him to the doctor. And when I tell the officer, like, he's have like a rank, he was like more than a regular security guard. I don't know what he was. A counselor, they called him inside. When I tell him that he got to take the man to the doctor, he say, you don't tell me what do I need to do. We go by the law and this and that, and we have rules over here, and you gotta follow them. If you don't follow them, you get in trouble. I can put you all to everybody. We're 60 persons in there. And I can put you all in the hall. The hall is a place where you can take a shower 1 day a week, and you eat once a day, and they put you there for anything. If you like try to speak up yourself, they try to keep you like, if you speak up yourself too much, they try to ¿cómo se dice amenazar? Threaten you, that they're gonna put you on the hall if you keep, like agitating the people that's there, or you keep telling them that don't receive that disrespect from them. And this guy, they didn't give the guy a medical attention in there until the next day. They fill up the paper, and they give the medical attention to the guy until the next day.
Wow. Well, Ms. Shirazi, after hearing stories like this, can you give us a rundown of the difficulties of representing your clients in detention centers? Because this is, obviously really bad.
Right. First of all, I want to thank the ACLU for bringing awareness to this very important issue. Certainly, there are so many human rights abuses occurring in facilities like CCA, and I want to thank the ILS for giving us the forum to discuss it with you this evening. I think what I can bring to the table today is to talk to you about what it's like to navigate a private facility such as the Stewart County Detention Center, and what the logistical problems are from a practitioner's perspective. And I think mostly what is so difficult for us as private bar lawyers is having access to our clients. And while I feel strongly that it's the role of ACLU and other activist organizations to be activists and raise awareness about these issues and come and protest, I think the role of the private bar attorney is more to create relationships within the confines of the limitations that we've been handed so that we can vigorously represent our clients' interests. So when things happen like what happened to Jose, we can call a supervisor and say, my client is experiencing severe medical symptoms, and based on your relationship to that person, you may be able to get something done. Otherwise, months can go by, and people have lost children behind bars, people have died behind bars, and without a good advocate, and which comes, I think, from establishing relationships and building your reputation with the ICE officers, with the judges, with the DOJ attorneys that you're trying to negotiate with, that comes over time. And if you create those relationships, then you're able to get things done with your client. And I'm not saying I don't feel enraged about these things, because I do, but I think as a private bar lawyer, it's in my client's best interest to stay a bit more behind the scenes and not be on the front lines being an activist, because I think ultimately it could hurt my clients. So some of the things, to answer your question, is the logistical problems. And there are several detention facilities in Georgia. Irwin and the North Georgia Detention Center, if we want to file a bond motion or something of that nature, we go into Atlanta. That's the immigration court that has jurisdiction over those two detention facilities. So we're able to go in person and meet with the DOJ attorneys, meet with our clients, meet with the judges. When it's in Stewart County, it's about 3.5 hours away, and it's in the middle of nowhere. And I mean, let's be honest, we're private bar attorneys, so it does cost money to hire us, and just the practical ramifications of taking an 8-hour break to go down there, you have to pass on that fee to the client. In many cases, they can't afford it, so we have to appear over the telephone. And that obviously is not the most judicious use of our abilities, and certainly not giving us access to the clients. And if there's a language issue that's not Spanish, we have to bring in the interpreter through another phone conversation. So there's always technical difficulties. And so mainly what I would say, dealing specifically with Stewart, is just the logistics of trying to have access, of being able to communicate, and certainly even when it comes to dealing with ICE, we have to deal with the Atlanta office in many cases to do things like stays of removal, and then we have to rely on the government to get word from Atlanta down to Stewart, and as we know, that can oftentimes be problematic. So you have to, like I said, again, revert to your relationships and have those emails and forward copies of things you served in Atlanta. So it just makes everything more difficult.
Ms. Guerrero, coming back to you. So will you please tell us a little bit about END campaigns?
So some of the things that we work with through NIA, which is the National Immigrant Youth Alliance, and Dream Activists, are END campaigns. END campaigns stand for Education, Not Deportation. And these are public campaigns that are organized by Dream Activists and by NIA to help stop people's deportation. So whether the person recently got stopped 2 hours ago and they're in the local county jail, or whether they're already inside a detention center, or whether they've been released but they're still in deportation proceedings, we go ahead and launch END campaigns. And we make public campaigns through Facebook, Twitter, through news, media, and we basically do petitions, and from the petitions, we ask to help stop people's deportation. So if you guys ever seen one, it says sign so-and-so's petition, help stop their deportation. From there, we also talk to different, for example, legislative offices. For example, if there's a representative who supports you and supports immigrants' rights, and they're willing to sign the letter or make a letter of support for that person, that also helps a lot. If they're willing to make a phone call, if they're willing to pick up the phone and call Immigration Customs Enforcement and ask them to release so-and-so. A lot of the times we get many of our cases by folks who are stopped in Cobb County for driving without a license. So as soon as they hit the local county jail, they'll call us and they'll be like, hey, my aunt's in jail, my uncle, my brother, whatever it might be. And we've been able to form a relationship with Immigration, which is the Atlanta ICE office, the local ICE office. So I go ahead and email them, and we have the contact person inside Atlanta, and I let them know, hey, there's a mom in Cobb County. She has 5 kids. She's been here 10 years. She has no criminal record. You stopped her for no license. And we ask you that you not pick her up from Cobb County. And recently, in the END cases that we've been doing in the last couple of months, we've been successful with Immigration not picking them up, meaning that they let them go from Cobb County Jail. So they save the immigration bond, which is usually $7,500 for no license. So they save that, and then they also save the hassle of being transferred from Cobb County over to Atlanta, over to a detention center. So they also save that hassle, and it saves them time. So if folks are able to call us fast enough and soon enough, we're able to contact Atlanta ICE. We're able to let them know, hey, there's this person, don't pick them up, because they're low priority for deportation, meaning that they don't pose a threat to the community or to the society or whatever it might be. So it just depends on each case. Each case is different. None of the cases are ever 100% guaranteed, but we have been able to create that relationship with Immigration. So every time I send them an email, they know exactly why I'm emailing them. They know exactly what I want, et cetera, et cetera. So.
Professor Price, coming back to you, why don't detained persons have the right to an attorney or similar protections that we associate with trials, such that they would have to rely on END campaigns?
Well, if you didn't know the answer, you wouldn't believe me if I told you. But the answer is that deportation and removal proceedings and the detention that accompanies it is a civil proceeding. It's not a criminal proceeding. And so, since it's not a criminal proceeding, this is America, and in America, in a criminal proceeding, we've got the Bill of Rights that we've honored for a long time. We don't honor it in civil proceedings. And why is forcing someone to leave this country, to be in detention for months, maybe years? How can that possibly not invoke some of these constitutional rights? Well, it's because the United States Supreme Court said so. And again, it's partly, as I said earlier, it's that plenary power doctrine that basically says Congress has complete control here. But if you would just indulge me for a minute, I want to read from that case that established this proposition in 1893. And it says, the order of deportation is not a punishment for crime. It is but a method of enforcing the return to his own country of an alien who has not complied with the conditions which the government of the nation has determined that his continuing to reside here shall depend. He has not, therefore, been deprived of life, liberty, or property without due process of law, and the provisions of the Constitution securing the right of trial by jury and prohibiting unreasonable searches and seizures and cruel and unusual punishments have no application. So again, if you didn't know that already, you probably wouldn't believe it if someone told you on the street that this is how we deal with this. So the most important, there are many important ramifications of this, but there's no right to have a lawyer provided as would be provided by a federal public defender, for example, if you're charged with a federal crime or in the state courts, have a lawyer provided. If you can have one, you're certainly entitled to have one if you can afford it or if agencies are able to help you with this. But in the immigration courts in the United States, it's only 1 out of every 8 non-citizens that is actually represented by attorney throughout all of these proceedings. So there's this great need for more work in this area.
Thank you. Ms. Shahshahani, will you please specify some of the most egregious problems that occur in these facilities, such as issues with due process, lack of access to medical care, et cetera, that you point out in Prisoners of Profit?
Right. So, the areas of concern that we covered were, based on what we observed, the patterns that we observed were due process concerns, inadequate living conditions, and inadequate medical and mental health care, as well as abuse of power. So due process concerns, Ms. Shirazi and Professor Price have already laid out some of the problems. I think the biggest problem is how far and remote these facilities are. As Amna mentioned, Stewart is 2.5 hours, Irwin is 3.5 hours, which makes it really impractical for attorneys to go down there and for advocates and communities of support to go down there. And also the issue that I would just mention, the lack of court-appointed attorneys means that a lot of immigrants are going to have to rely on pro bono services, which in Georgia are, there's not a lot of organizations that are doing this work. Or if they're lucky enough, they can, try to get an attorney. But just to, relate to you a specific case of a person who didn't have representation was one of our clients, Mark Little, who is a U.S. citizen, born and raised in North Carolina with mental disabilities. And so Mr. Little touched a person inappropriately when he was in North Carolina, and so he ended up at the North Carolina jail. North Carolina has one of these local enforcement agreements and partnerships with the federal government, and so an official there, based on really what came down to racial profiling, because Mr. Little looks brown, decided that Mr. Little is not a U.S. citizen and that he is Mexican, and his name is Jose Thomas. Even though Mr. Little was protesting, all throughout and saying that, no, I am in fact a U.S. citizen, and if they had done minimum due diligence, they could pull up his records and, his social security number, and it was, obvious that he's a U.S. citizen, but they didn't listen to him. They turned him over to the federal government. The federal government also failed in their duties. And so he went through the process without having representation. An immigration judge issued a deportation order, and he was detained at the Stewart Detention Center for 6 weeks. And at the end of that, he was taken to the border in a prison jumpsuit and left to his own devices with having $3 in his pocket and speaking no word of Spanish. And so for the next 4 months, Mr. Little had to wander the streets of Honduras, Mexico, Guatemala, and Nicaragua, living off of shelters and begging. And finally, at the end of 4 months, he made his way to the U.S. consulate in Nicaragua, and somebody took the time to listen to him. They contacted his family in the U.S., and so they sent over the documents, and so a U.S. passport was issued, and he was able to come back. But this is not an isolated case. There have been U.S. citizens before, U.S. citizens with mental disabilities or not, who have been detained and deported. And the fact of the matter is that at this moment in time, we're not providing anybody the government or the court isn't providing anybody in removal proceedings with representation, and as such, there have been people who can't even say their own name or remember their own name, and they're expected to navigate this process on their own. So this is, I think, the most significant due process violation that, that is in the system in Georgia or elsewhere. In terms of inadequate living conditions, we already mentioned the problems with the food, with hygiene. So for example, at Irwin is one of the facilities that detains women as well as men. The detainees are not provided with fresh underwear. They're given used underwear, which at least in one case led to a very serious infection for a woman detainee. Also, there is no outdoor recreation at the Atlanta City Detention Center, and this was actually a point of contention between us and ICE, because we toured all the 4 facilities, we went to ACDC as well, and we spoke to all the detainees, and they said there is no outdoor recreation. We've been here for a few months, we haven't seen outdoor space, we haven't been able to spend time outside, and so we contacted ICE, and ICE said no, there is in fact outdoor recreation. And so there was some back and forth, and then finally we figured out what they were referring as outdoor recreation was this enclosed, space, a basketball court with this little hole in the wall with some sunlight, some rays of sun coming down. And that's what ICE means by outdoor recreation. Segregation, solitary confinement is a huge problem. So, it was already mentioned, the arbitrary manner in which people are placed in solitary confinement. Basically, a guard decides that a detainee isn't behaving appropriately or is getting on their nerves, and so that person is then assigned to solitary confinement. And there is not really any due process afforded to ensure that the person can come back to the general population with actual due process afforded to them. And this has led to serious mental health issues among the detainees. We actually were prevented access to 2 of the solitary confinement units at the Stewart Detention Center and Irvin County Detention Center, which of course raised the red flag, and we never were provided a good reason for why we were detained, we were denied access. But at the Atlanta City Detention Center, where we were provided access, and we went in, it was just one of the most horrifying experiences that I've ever had. In terms of screams from the detainees. There's a lot of people with mental disabilities who are placed there instead of being provided the medical and mental health care that they need. And again, even if you're not, you don't have a mental health situation, if you spend 10 days there in a small cell with 23 hours inside the cell, listening to the screams of others and not having any human contact, you're guaranteed to have some kind of mental health situation by the time you get out. In terms of abuse of power, is a serious problem. We already mentioned just the arbitrary nature in which people are placed in solitary confinement. We documented physical abuse at 2 of the facilities and verbal abuse at all of the facilities, and this often meant racist slurs and humiliation. And just wanted to read a quote from Pedro Guzman, who actually is a man who's featured on the cover of our report. And thankfully, he's now out and reunited with his family when his attorney was finally able to convince the government that Mr. Guzman doesn't pose any risk to society. So he's been reunited. But after spending 20 months away from home, Mr. Guzman says, "You lose faith, you feel worthless. This place breaks you. It is made to break your soul. The constant screaming and verbal abuse the guards inflict on the detainees is just made to break your soul and handicap you."
Wow. So I'm going to go back to Ms. Shirazi. I understand that there have been issues with detainees being coerced or forced into signing voluntary removal orders. What is a voluntary removal order, and why is this a problem?
Well, first of all, I think it's important to differentiate between a voluntary departure order, which is considered to be a benefit that's granted to somebody to be able to leave voluntarily from the United States. And depending on the amount of time you've had here, the amount of ties you have to the community, whether or not you're considered a danger to the community, and you have valid travel documents, you can get anywhere from 30 up to 120 days to voluntarily leave the United States. You have to demonstrate that you're able to buy your own airline ticket, and then they basically say, see you. So if you think about this in the context of detention, it really doesn't make any sense, because what a voluntary departure order in the context of detention means, they say that they grant you voluntary departure under safeguards. And what that means is that you're not allowed out on a bond to wrap up any of your affairs during that period. So having a voluntary departure order in that context really doesn't do anything unless you have a family member who can sponsor you to return, and they're able to pay for an unrestricted ticket that they will use at their own disposal to remove your loved one, in this case, from the United States. So more to the point is the judges rarely grant this in the context of detention. They typically just order a person removed from the United States, deported. And to add, sort of bridge from what she was, Ms. Shahshahani was saying, and also what Professor Price was saying, is that because so many of these detainees don't have access to adequate legal representation, in these administrative proceedings, the judge oftentimes is educating the detainee about what their options are with respect to any sort of relief from removal. And obviously, in this sort of situation, they're not giving the best legal advice. They're not advocates for the individual, and they're not looking at things from a practitioner's side or a viewpoint. So, not to mention what I think is a conflict of interest. How can a judge, be in a position to be advising somebody, what their rights are in that situation? It really, to me, seems like a faulty system in that regard. But what ends up happening is that the judges will give the client limited options and basically say, or, I can sign your order and you can just go back home. And I know the attorney that represented Mr. Guzman. He's actually a very good friend of mine, and I followed that case very closely. But I think his words were very true to what most of the people who are detained at Stewart feel. I've had clients who just get tired, and they just say, I don't want to do this anymore. I had a woman just 2 weeks ago who was poorly represented at her first master calendar hearing by another attorney who basically, without getting too technical, made it so that she was not eligible to apply for a bond because her attorney made an admission that prevented the judge from having jurisdiction to be able to give a bond. She actually had a very good asylum case. She was from a marginalized group of people from Guatemala, the Quiche tribes people, and she was escaping the persecution of people in her town who thought because her husband was in the United States, she was getting money from here, and they had raped her and consistently tried to extort money from her. She was able to get here because her attorney botched the situation, and she'd been detained for 4 months. When I went into the master calendar hearing to try to re-plea the initial charging document, the judge wanted to set it down for a hearing months from now. And because she'd already been detained for 4 months, she basically was at a breaking point and said, I just can't deal with this anymore. I cannot live like this anymore. I just want to sign my deportation. So, she took her chances, and I basically had to file a motion to get her back in front of the judge to go ahead and accept the order, not because she didn't have a good case, but because she didn't want to sit in jail at this facility knowing that I couldn't get her out, and then maybe being able to if I won the case. So I would say that it's certainly a problem with the individuals not getting the legal advice that they need at the right times.
My final question will be for Ms. Shirazi, and then for Ms. Shahshahani, and then I'm going to open it up to questions from the audience. So I think it's a good place to close to say if you could tell us a little bit about expose and close.
Right. So if I may talk a little bit more generally about what people can do, and I'll end with expose and close. So there are listservs. I mean, there's a sign-up sheet to join the Georgia Detention Watch listserv if you're interested, and that's a coalition that we founded about 4 years ago, and basically our purpose is to monitor and expose and you know, hopefully end the inhumane conditions at some of these detention centers, and also to shut down the ones that are, you know, really horrible, like Irwin and Stewart. And there's also copies of our report outside, and feel free to take one. And one of the ways, too, that law students can get involved is through humanitarian visitations. So again, if you sign up for Georgia Detention Watch, or if you're interested, you can talk to me. You can go down for a weekend to Stewart and have a chance to visit with the detainee and hear about their story. And as those who have been inside can tell you, having a visitor is really important, emotionally. A lot of the individuals at the detention centers don't have any visitors because their families may be in another state and far away. So it's really important for those of us who can to go down and provide them with some company. And then lastly, Expose and Close is a national campaign. And the purpose is to highlight 10 of the worst facilities in the country. And 2 of them are in Georgia, the Stewart Detention Center and the Irvin County Detention Center. And I should mention these are the same 2 facilities that we had recommended in our report that ICE should stop detaining immigrants in. And so there will be 10 small reports released on November 15th, highlighting the conditions at the facilities and urging ICE to basically shut these places down. And the next day, there's going to be a vigil at the Stewart Detention Center. This is our annual vigil that we've had now for about 5 years, and people are going to go down from Atlanta. And this is actually the weekend of the School of America's Watch, where a lot of people come, about 10 to 15,000 people come from around the country. There's also a good opportunity to tie the 2 in. And so we're going to meet at the Lumpkin Town Square and then march up to the gates of the Stewart Detention Center and have a vigil there. We also get the message to the detainees. And so we hope that ultimately, all of these efforts will lead to the closing of Stewart and other inhumane detention centers in Georgia and elsewhere.
Thank you. So now I'm going to open it up to the audience. If you guys have any questions for our panelists. Yes.
Could someone address the Board of Immigration Review certification for practitioners?
Could you hear that? Should I? Yes, I should. Okay. Let me see if I can. Thanks, Deb.
Could someone address the Board of Immigration Appeals Practitioner Certification and how that can help some of the people who are detained?
Well, from what I understand, and actually I just kind of turned to Ms. Shahshahani and asked her if she knew, but and she also was a little confused about it. But from what I understand with the BIA, which is the Board of Immigration Appeals, there can be advocates that are certified to practice in front of the board and also go to immigration court. I've never run across anybody who's been certified in this manner. And in order to get that certification, obviously that implies that person is not an attorney. That said, I honestly don't know what the process is, and I'm not sure that I would, I mean, how can I say this diplomatically? I think that to practice in front of the Board of Immigration Appeals, I think it does take somebody who's gone to law school, because the people who are writing the opposing briefs are lawyers who've had years of practice in this field. And so as well as this person may be qualified in terms of their passion and their commitment to the job, at the end of the day, they're going up against attorneys who went to some of the finest law schools in the country, and you either write a winning brief or you don't. And the board is very quick to dismiss cases where no real legal issue is raised. So again, I don't know how to better answer that question. Do you have anything?
So I would like to, is that okay? I want to thank Elizabeth who invited me, and this has been quite eye-opening for me. I didn't know, Professor Price, I didn't know that being in this country without documents was not a crime. This is the first time I hear this. I always thought, I guess because of the media, that being here without proper documentation was a crime. I didn't know that it wasn't. And I appreciate you opening my eyes to this subject. I wanted to tell Dulce and Jose that as far as I'm concerned, you guys can stay. It's not up to me. If you are good citizens and work hard, we need people that work hard. There are many people that don't want to work, and so I appreciate you working hard and being good citizens. Anyone wants to?
I don't really need the mic, actually. Like, I'm pretty loud. Well, thank you to everyone. Thank you, especially Jose and Dulce, for being here. I think you both are very brave. So we all know there's an election on Tuesday, right? Hopefully everyone in this room will come vote. We'll go vote, right? And hopefully we all will get the president that we want again. But everyone is going to vote for Obama. Anyway, but let's say that doesn't happen. So it's really directed at anyone on the panel. What do you foresee being the situation, especially in terms of immigration, should Mitt Romney become president?
That's a professor question.
Okay, well, to the extent that's a professor question, let me try this approach. I was talking earlier about how much power Congress has, and so I might even argue that it's more important the makeup of Congress than the executive. But at the end of the day, the president can veto, and as we know from what President Obama has done, there's extensive executive authority that can be exercised for the good, such as we've seen recently with the DREAM Act stalled in Congress, and yet President Obama finds a way with the executive power. And it really is phenomenal, the extent of the executive power. So like ICE, for example, when they're making, this is executive branch, when they're making detention and bond decisions, and when the ICE is basically acting as a prosecutor and judge at the same time, it matters very much what policy they're following. And it's the president that sets that policy.
Thank you so much for your presentation and for your time. I had a question regarding recently there was an Arizona law that went before the Supreme Court, and the Supreme Court ruled on it. And Georgia had a model law that was also before the 11th Circuit. I was wondering about the proceedings regarding that case, and how has the holding of the 11th Circuit affected the situation of immigrants in Georgia? Thank you.
I can answer that because we were involved in the litigation around House Bill 87. And so right now everything is on hold because what happened was that oral arguments on the case were heard in March before the 11th Circuit. And actually, let me backtrack. After Georgia passed this law, the ACLU and other organizations and attorneys brought a lawsuit to try to block some of the provisions. And so the district court blocked two of the most egregious provisions of the law, the Show Me Your Papers provision, as well as a provision which would make a state crimes out of transporting or harboring or inducing somebody to come to Georgia. And the state of Georgia then appealed that decision to the 11th Circuit Court of Appeals. And so, as I said, oral arguments were heard in March, but the 11th Circuit Court of Appeals decided to postpone a decision until the Supreme Court came out with a decision on Arizona. And the Supreme Court issued this decision, as everyone knows, and blocked three of the provisions, but crucially didn't block Show Me Your Papers. And the 11th Circuit then issued its decision in August, and then very much relied on the reasoning of the Supreme Court. So on Show Me Your Papers, it said that as the Supreme Court has said, right now we can't, we're not going to block this section of the law because you haven't shown that the state is going to implement it in an unconstitutional manner. So you have to wait for the law to be implemented and to document the profiling and the prolonged detention and other abuses and then come back before us. And it did, though, affirm the decision of the district court on the transporting and harboring provision. But the state of Georgia wasn't happy with the decision on the transporting and harboring provision, and so they filed a petition for rehearing. And so the 11th Circuit hasn't issued a decision on that yet. So at this moment, everything is on hold, and we have to see how they decide. But assuming that the Show Me Your Papers is implemented at some point, then what the ACLU and partner organizations and attorneys have to do is really to closely document how the law is being implemented around the state, with the hopes of going back to the court and showing them the evidence of how this law is being implemented in an unconstitutional manner.
Jose, we're honored by your presence tonight. And we hear a lot about Stewart and the individual things. We hear a lot about food. Could you just give us a couple of examples from your perspective where just mistreatment and malfeasance was carried out? In other words, that people were actually hurt by the system.
The food is terrible. And the first, you used to eat, like, at least in my house, we eat frijoles, beans, every single day. I don't know in other Hispanic houses, but in my house, we eat frijoles. And with that, I'm happy. Frijoles y tortillas y queso, I'm happy with that. But right there, they give you this food that sometimes have maggots in it. For real. And they give you, every 15 days, they give you chicken. And the chicken sometimes is raw. And people get sick because of that. And they give you this Kool-Aid to drink that is not sweet, but if you see the cups where you're serving every day, they have like a rust stain on the cups because it's so strong that if you drink that every day, you will get sick eventually. And that's one of the things. And I had an altercation with one of the counselors in there once, and it was because I have a problem on my column that if I have to go to the bathroom, I have to go when I have to go. It doesn't happen like every day, but they have a rule every day. They in that place that they count you almost about seven times a day in 24 hours, I think. So on that time, you cannot even go to the bathroom or do anything else. If you have to go, there is people in there who take heart medication, and they gotta drink water, and they gotta go to the bathroom every time they gotta go. And this lady come to us and tell us that in count time, we cannot fucking, excuse my words, I'm sorry. We cannot go to the bathroom or go, but she said in the bad, really, and she was yelling at us, and I told her that she shouldn't talk to us like that we respect her, that she should have respect us, and she was like, EUMFs, and I'm gonna bring the other guys. I'm gonna bring somebody who's gonna put you in place, and And she bring 4 guys, and one of the counselors, one was a higher rank on there. I don't know what he was. And when I asked the main officer to listen what did happen, you know, what I told her and why she got upset, and he was like, "Hey, you MF," and he started just cussing out of me to me. And he took me out, and he went on me, and he threatened me with a bunch of things in there. And he was saying that he was gonna break my mouth. He was trying to prove me that he was more man than I was, just because I was a detainee in there. If I hold myself because my kids, my wife, you know, I want to stay here. If I did something when he was right in my face, telling me all this, maybe if I was younger, I would have done something that I would regret it. But I hold myself, and then after all that, he told me, "Go over there and tell all these MFs that I can put them on the hold for 30 days to each one, and nobody will know about it." And right there, sometimes that officers from ICE, like when they assign you an officer, you go to the officer and you ask him about your case, and they just go once a week. And they don't even spend an hour on each cell, not even 15 minutes, not even 10 minutes. They just go, they show their numbers, because you have a number, and each officer have some numbers, like 6 or 7 detainees that they attend on that number. So they just go over there. Sometimes you ask them stuff about your case, or when you're gonna be deported, or something like that, departure. And they don't tell you nothing. They just tell you, you're leaving next week. And when I first asked my officer, he said that he was going to deport me within 1 week. And when my order of deportation got stopped, he went to tell me. I asked him, and he told me, "Don't worry, in 2 months, you're going back to your country." You know, I was fighting with my lawyer. You know, my lawyer was fighting for me to stay here. But my officer, he was like, in 2 months, he didn't say, like, he shouldn't say nothing, you know. But he felt that he had all that power over me, that he said that he was going to deport me in 2 months.
Thank you very much.
You're welcome.
Hi. My question deals more around the laws. I know that we keep hearing about all these pretty much human right violations and all these inhumane treatments they're experiencing. I mean, what about our laws of the land? I mean, if people are dying behind bars in these institutions, the people are being hurt, there's no laws that go against this? I mean, what's stopping them from just murdering all the people that come through? Like, I'm trying to comprehend where our legal system even comes into this picture.
I think that in many cases what happens is you file a civil lawsuit, and unfortunately when you do that, you have to go through the process of discovery and showing that the facility was negligent and having the funds to fund a case. I mean, it comes down to practical issues. It's not very common where it's not very common for a police officer or a warden of a jail to be charged with a crime. But more often you see these being dealt with in civil cases. And ultimately in a civil case, you have to show that there was negligence, obviously. And if you think of it from a practical side, when an attorney takes a case that's a negligence case, typically at the end of the day, it's on a contingency. So funding that discovery process, being able to do the FOIA requests, which should take 2 weeks, oftentimes take 2 to 3 years. Seeing, unfortunately, and especially in the immigration process, a lot of the records are released redacted, so critical information is not even there. There's actually a civil case that was filed against, and I believe it was Stewart last March, where a 39-year-old died died in a hospital, but after they had not provided him with any medical care, and he ended up dying of like an inflammation of the heart, which could have easily been detected had he been given the medical exam that he should have been given to begin with. And I think it was in 2009 that Napolitano said that every detainee has to have a medical exam. But when the AJC pulled the FOIA records, they found that they did not actually give him a medical exam, that it wasn't even doctors that were looking at his x-rays. And while the heart defect that he had could have been easily detected by a medical professional, they had civilians working for the jail signing off and saying everything was okay. And then when he asked for medical care, it just wasn't given to him fast enough. So there's a civil suit pending currently, but it's rare. And in this case, there's a smoking gun, and that's not always the case, unfortunately.
Right. In that case, actually, that we brought with attorney Brian Spears, it's been settled. But, as Ms. Shirazi mentioned, there are a lot of hurdles, including immunity, and of course, in the case of private practitioners, all the cost of litigations, and also, to have a willing plaintiff, and if God forbid you have somebody who has died, willing family members who are willing to come forward and contest it. It's the government and the courts have unfortunately put up a lot of obstacles and hurdles to successful litigation. And another sort of overarching problem is the fact that ICE has for a number of years refused to put into place a binding system of standards for regulating the treatment of prisoners, of the detainees at these facilities. So there is a system of guidelines, but they only serve as recommendations for how these facilities should operate and the treatment that the detainees should be afforded. So you really can't rely on those for bringing a lawsuit, but you can try to lobby ICE to bring the standards up to par with their own standards.
One of our audience members brought up a good point that FOIA, the Freedom of Information Act, doesn't actually apply to private corporations. Do you want to speak to that a little bit? Oh.
Right, and that's another big problem. So, and it's not only ICE, it's also the BOP, Bureau of Prisons, that has contracts with the private corporations, and there are two facilities like that here in Georgia, the McRae and the D. Ray James facilities, and both of those prisons basically imprison immigrants before they're turned over to the custody of ICE. And these are people that the government has put on trial for crossing the border basically to reunite with their families, and that's a crime under federal law. So they're prosecuted and they're convicted of that crime, and then they're put into those private facilities, and then they're turned over to the custody of ICE. So we actually, with Laura's help, have a FOIA pending right now against the BOP for operation of the D. Ray James Correctional Center. And they got back to us and said that, well, there's limited information that we can release to you. So whatever is in our possession, we can try to release to you maybe like 2 years from now. Who knows when we're going to get that information. But the information that pertains to the company has it, and they don't fall under the purview of the Freedom of Information Act. There's some states like Tennessee where the courts have in fact held that because they're contracting with the government, they in fact should fall under the State Public Records Act and the purview of it, but that's not the case, at least right now, in the federal system.
Thank you all for being here. Dulce, I'm wondering if you could speak, since you're a dreamer yourself, if you could speak a little bit about DACA and whether you feel like it's given hope to the community of dreamers.
So for people that don't know, DACA is Deferred Action for Childhood Arrivals. And it's basically an announcement that was given out during the summer, which basically means that if you are a dreamer, meaning you came into the United States under the age of 16, you completed high school, you have a GED, you've lived in the United States for 5 years continuously, and you don't have a criminal record, 3 or more misdemeanors, or a significant misdemeanor, you would be able to apply for a work permit. From that work permit, you would be able to apply for a driver's license. So when the announcement came out, I think it did give a lot of students hope, just in the sense that deferred action means that they're not going to deport you for right now. It doesn't mean they're going to give you permanent status. It doesn't mean that it's ever going to be a pathway to citizenship. It just means they're going to stop your deportation for right now. So it's going to be 2 years, and you get to apply. And I know a lot of folks have applied already. They've obtained their work permit, and they're going to get their driver's permit. So like I said, a lot of folks have applied for it. I think it's good for students who, you know, like myself, who came in as children, who are under the age of 30, but I think we're talking about a very narrow group of students when we talk about undocumented students, because I know students who came to the United States as children, but now they're 31. So what happens to these folks that graduated high school, that have their degrees, but now they're 31, so they're not able to apply? So are they all of a sudden not good enough for this, you know? What about our parents that did come to this country? They work hard, they pay taxes, they do whatever they need to do, but now they're still at risk of getting deported. They're still at risk of driving without a license. So in a sense, I feel like it was relief for students, at least for 2 years, at least for these 2 years. We would have to see what happens next 2 years and the 2 years after that. But then we also have to understand that it's not a path to citizenship or residency. It's simply, something they give for 2 years, for 2 years, for 2 years. So it's not permanent at all. I think it is very narrow when we talk about like undocumented people. It's not just about students or just about dreamers. Like we have people who are over the age of 30. We have parents who have been in this country for many, many years who won't be able to apply for this.
I want to take the microphone to you, but in the meantime, since I have the microphone, oh, you don't need it.
Could you describe to us the process you went through for being released? And then Amna, could you tell us how hard it would have been for him to be released, like some of the barriers you would have faced in trying to get the necessary paperwork? Or, I mean, you already spoke to some of it, but I mean for his specific case, for him to be released.
My case was in New York. I had a case that I didn't know until I got pulled over in a checkpoint, and they put me in jail, and they put me in immigration hands. So I did have to wait for that case to be moved over here to Georgia. And then there was a process to stop because I was already departure, but I didn't know. So they did have to reopen my case for me to be able to stay over here. But before that, they got to do what they call is stop the departure, where they cannot departure. They fill up papers and they send it, and it takes 30 days for the paper to go and come back. And sometimes, if you're inside, it takes about 2 months. And you gotta wait that long for you to be able to get that paper that it say that you cannot be removed for just that moment. But that doesn't mean that you're not gonna be deported. That means that they cannot deport you for some time. I don't know. You can be in jail for a year if they don't reopen your case. So what did they tell you when you're going to sign the papers? They say to you, the ICE officer say to you that will take from 6 months to a year. So you got to be all the time in prison. You got to wait for all the paperwork and everything to come out. So my case was in New York, but they reopened my case in New York, and when I did have to wait about 2 months to move it over here. And when they moved it, my officer, he didn't want to let me go. He had the power to not let me go for some reason. And I have a bond, you know, and he said that he didn't want to let me go. I didn't have a criminal record. I didn't, you know, they reopened my case, and when they reopen your case, you're eligible to have a bond where you can get out and, you know, and wait for your trial. And he didn't want to let me go. And until my lawyer called his supervisor, and their supervisor tell my ICE officer that he have to let me go with the bond. But he even told my lawyer that he wasn't gonna let me go. But I don't know, maybe somebody know what type of law is that, you know, that you have the right, but you don't have it because somebody can say, no, you don't.
Jose, I'm sorry, he grew fond of you because you're such a nice guy.
Without giving him an interview like I would in my office, I'm going to glean from what he said that he sounds like he had an order in absentia in an immigration court in New York. If you have been ordered deported in absentia, meaning while you were not present in court, which the immigration court has the authority to do, if you do not come to your immigration court hearing, they will immediately order you deported in absentia. So what happens, and in situations like his, they may find out, individuals may find out after they've done something like driving without a license and they get the ICE hold, that they have an order of removal in another immigration court somewhere in the country. And actually, the fact that he had it in New York was beneficial to him, because had he been deported in Atlanta, it would have been a lot harder to get that case reopened. There are much more liberal immigration courts that I've been able to get cases reopened in. For example, San Diego, Los Angeles, New York, Boston, Chicago. These are courts that seem to be more friendly to the plight of immigrants than, unfortunately, the jurisdiction I have to work in every day. But so what you can do when someone's been ordered deported in absentia, there's an automatic stay of removal until you can prove that this person was either given no notice of his hearing, and you can do that by various methods, and I'm not going to go into what they are, but one example that's glaring is he filed a change of address form and they sent the notice of hearing to his old address, and he has proof that he changed his address. Stuff like that happens all the time. So in the meantime, while you have the motion pending with the court up in New York, he's not allowed out on a bond. Until the immigration court reopens the case, he basically sits in jail. And depending on how backlogged that court is, he can sit in jail for months. Once the case is reopened, you have to show either that the person had received no notice, or that you can show some compelling ground and convince a judge based on a humanitarian reason, and maybe get the DOJ attorney in that jurisdiction to join you in a motion to reopen. And that happens when there's particularly, egregious humanitarian concerns. But once the case is reopened, you can then file for a change of venue to the place where he's detained, and then you file for a bond. You get a reasonable bond set, but you have to show that he's not a flight risk, a danger to the community, and that has some form of relief from removal. If you can't show all of those things, then they still won't get on a bond, even though their case is reopened. They'll have to sit in jail until such time that they've been granted some sort of status. So, that process can take a year. I mean, it can, just depending on the jurisdiction you're in, how quickly the attorney is able to turn the work around, because you don't want to submit a poorly written motion. You certainly want to try to get the government to join you in a motion if possible. All of these things take time. In the meantime, the individual sits in jail. As to the issue of his immigration officer not letting him out after a bond has been set, I've never heard of that happening. It's a crazy story. I'm not denying that it happened. It's unfortunate that it happened. But in my almost 13 years of practice, I've never run across that where a bond has been set because you go pay it here in Atlanta and then they send the orders of release down to Stewart or wherever. But maybe there is something. You did. No, just kidding.
No, he didn't even let us know, not even my lawyer. He didn't want to let us know that I already have a bond.
But that's, okay, so, and there's certainly those types of things happen, but typically when a bond is set, it's set by an immigration judge, and you take the order to the ICE office in Atlanta, you pay the bond, and then the ICE office in Atlanta sets the order down to whatever facility you're in, and they release you. But certainly anomalies happen. I don't want people to think that's normal, because it's not. I don't know what happened in that case. I can't speak to that issue.
Because my lawyer, she was the one who talked to the officer, and she told me what the officer said to her, and she did have to call twice to be able to get, go ahead and pay the bond for me.
If I could just ask a quick follow-up, I'm sorry if this is a dumb question, I'm not a law student, but how would someone get summoned to court without knowing that they were summoned to court? If you could just give like a brief answer, like.
I'm sorry, I didn't understand that.
I'm sorry, so you mentioned people not receiving the order to go to court.
Right.
What would be the reasons that people would be ordered to court without knowing that they were being ordered to court? I don't know if that makes sense.
Well, I mean, people are put in removal proceedings all the time if they affirmatively apply for a benefit with the immigration at the time, the INS, and now USCIS. If you affirmatively apply for a benefit and it was denied, sometimes you never get the denial notice, but CIS will go ahead and transfer the file over to litigation, and an NTA is issued, and by then you've moved. I mean, there's so many different scenarios for how that happens. And there are a lot of times where people don't even know they're in deportation proceedings or removal proceedings. I've had clients who didn't know they had a removal order from 15 years ago, and they've been just sort of operating as normal. So in most cases, it's people. In most cases, to be honest, people do know they're supposed to go, and they don't. In the good cases where somebody legitimately tried to go, or there was government error, which happens as well, you can try to fix it. But again, it goes back to the system. People's spirit gets broken in these facilities. I've heard of stories of detention officers taunting my clients, basically saying that you're going to get deported. You may as well sign this order. We can get you out of here. This is, just basic. And I have to sit there and tell them not to listen to anything they say. Only listen to what we tell you, because it does happen where there are good cases where you can reopen a case, but we're not talking about, murderers or convicted felons. We're talking about normal people who are sitting in a detention facility with other criminals, in many cases hardened criminals, and at some point, they just have had enough, and they will sign that order. I mean, I've had that happen countless times over the years. So
I think you can see how important it is to have an attorney, to sort through all this stuff. And, only 1 in 8, roughly, in immigration court has an attorney. And one of the immigration law judges, I think, do the best they can. But oftentimes, if the side's not even there or is not even able to explain what's going on, it's really tough. And one immigration law judge said he compared it to like hearing death penalty cases in traffic court.
Yeah, that's true. Well, we've got just a few minutes left, and I'd be remiss without saying my thank yous. So I've got some thank you gifts for our panelists, and if we can all just give them a round of applause.